Welcome back to the Constitutional Clarion. Australians are generally familiar with the fact that the only way of amending the Commonwealth Constitution is by a referendum. But are there other ways that you can change the scope and effect of the Constitution? In this video, I'll explain the other ways by which the Commonwealth Constitution can be changed. But first, let's start with the key provision for changing the Constitution, which is its last section, section 128. It starts by saying, "This Constitution shall not be altered except in the following manner." It then sets out the parliamentary and referendum procedure. The upshot is that if you want to change the words of the Constitution by adding or deleting text, then you need a referendum to pass. And of course, we all know how hard that is. But there are other ways of changing how the Constitution operates. First, the Constitution distributes legislative power amongst the Commonwealth and state parliaments. It follows the United States model by limiting the federal power to enacting laws on specified subjects while allowing the states to enact laws on any subject whatsoever, unless, of course, it's been taken away from them by the Constitution. If the Commonwealth and the states both enact laws that conflict, then the Commonwealth law prevails to the extent of the inconsistency. This means that the Commonwealth Parliament is often scrabbling around for what we call a head of power, which is the subject that is allowed to make laws about in order to be able to enact legislation on particular matters. Most of those subjects it can make laws about are listed in section 51 of the Constitution. But towards the end of that section, it gives two special powers. The first is section 51(37) of the Constitution. It allows the Commonwealth Parliament to make laws about matters referred to the Commonwealth Parliament by the parliaments of any of the states, but so that the law, this is the Commonwealth law, once it's enacted, only extends to apply in those states that referred the matter to the Commonwealth or which afterwards enact their own legislation that adopts that Commonwealth law. This has allowed the Commonwealth Parliament to enact laws it would otherwise have no power to make on a range of different subjects. They include laws about terrorism, family law and de facto relationships, corporations, water, credit and personal property securities, unexplained wealth, and the National Redress Scheme for the institutional child sexual abuse. You can see quite a handy list of each of those laws in relation to each state in this book, which is called Saw's The Australian Constitution. From one perspective, these references have the effect of changing the operation of the Constitution. Why? Because they give the Commonwealth Parliament an additional power to enact laws on particular matters, altering the constitutional distribution of powers between the Commonwealth and the states. But on the other hand, it doesn't actually change a word of the Constitution itself, and it is expressly permitted by the Constitution. So from that point of view, it's not an alteration of the Constitution that requires a referendum. It's just utilising an option given in the Constitution to adjust that distribution of powers between the Commonwealth and the states. Next, we have section 51(38) of the Constitution. It gives the Commonwealth Parliament power to make laws with respect to the exercise within the Commonwealth at the request or with the concurrence of the parliaments of all the states directly concerned of any power which can, at the establishment of this Constitution, be exercised only by the Parliament of the United Kingdom or by the Federal Council of Australasia. Now, let's not worry for present purposes about the Federal Council of Australasia. Maybe I'll do a video one day explaining it, but for present purposes, it's just not relevant here. Section 51(38) was included in the Constitution to prevent Australia from having to rely on the United Kingdom to enact certain types of laws for it. It was actually a bit of a sneaky measure put into the Constitution to give a degree of independence to Australia, which of course was still a colony of the United Kingdom after Federation. This is why the British were actually not terribly keen on section 5138 when the Constitution was enacted, and there was a bit of a ruckus about it. The gist of the provision was to ensure that collectively the Commonwealth and the state parliaments could enact laws to achieve an outcome that only the United Kingdom Parliament could have achieved at the time of federation. It has been used, for example, to legislate about the control of coastal waters off the states, to end Australia's residual colonial links with the United Kingdom, and to change the rules of succession to the Crown of Australia. Again, this provision changes the effect of the Constitution by expanding the scope of the Commonwealth Parliament's legislative power, but it is expressly permitted by the Constitution itself, and therefore these laws do not require a referendum. A more peculiar provision is section 105 capital A of the Constitution. It was added to the Constitution by a successful referendum in 1929. It authorises the Commonwealth to make agreements with the states with respect to public debts and borrowing. The Commonwealth Parliament is given power to make laws to give effect to those agreements and to enforce them. Now, the odd bit is in section 105A(5), which says that every such agreement shall be binding upon the Commonwealth and the states that are party to it, notwithstanding anything contained in this Constitution, or in the constitutions of the several states, or in any law of the Parliament of the Commonwealth or a state. Now that means that something could be put in one of these agreements, so long as it fell within the scope of section 105A, and it would override everything else in the Commonwealth Constitution. Now, frankly, that's mildly alarming, but so far has not amounted to anything at all. It's never been abused and it's not been an issue, thank goodness. Another way of changing the effect of the Constitution is through constitutional interpretation, primarily by the High Court. For example, in the recent Vanderstock case, the High Court changed the interpretation of the meaning of the word excise so that it means something now which is quite different from what it meant when the Constitution was enacted. The effect is that laws that would have been regarded as valid by the framers of the Constitution are now treated as constitutionally invalid because a majority of judges now prefer that outcome and that interpretation. By far the greatest change to the Constitution over time has occurred by interpretation by the High Court rather than by amendments passed by the people in a referendum. Indeed, the High Court's interpretation has often reversed the outcomes of referendums. For example, limitations on the Commonwealth Parliament's corporations power and its industrial relations power, which always quite annoyed the Commonwealth government, led to it holding referendums on the expansion of one or both of these powers in 1911, 1913, 1919, 1926, 1944 and 1946. Each one of those referendums was rejected by the people. The people refused to make the expansion of these powers. In 2006, however, in the Work Choices case, the High Court reinterpreted the corporation's power in a manner that effectively removed previous limitations on it and rendered the industrial relations power largely redundant. It did what the people had refused to do in all of those referendums. So the change was made to the operation of the Constitution by the High Court. To take another example, the Constitution does not provide for a universal franchise, that is, the right for all adult citizens to vote. Instead, the Constitution originally imposed the franchise as it existed in each of the states, which of course excluded many groups from voting. It then left the franchise as a matter for the Commonwealth Parliament to determine. In 1974 and 1988, referendums were held to impose a universal franchise, subject of course to some exclusions, such as the exclusion of persons with unsound mind and in some cases prisoners. Both referendums failed. In 2007, however, the High Court drew an implication from the Constitution that imposed a universal franchise. Again, it did what the people had refused to do by changing the Constitution, although in this case through interpretation rather than a referendum. Now there's one further possibility for changing the Constitution without a referendum, which was raised by one of my viewers and provoked this video. It's the use of Section 15 of the Australia Acts 1986. Now the Australia Acts are two separate acts that contain exactly the same substance. One of these acts was enacted by the United Kingdom Parliament, and the other one was enacted in Australia by the Commonwealth Parliament, relying on that Section 5138 of the Constitution that I mentioned earlier. And these acts cut off the residual ties between Australia and the United Kingdom. They ensured that even though some of our constitutional documents remain in British documents, control over their operation and application within Australia is now fully within Australian hands. The Commonwealth Constitution, for example, was enacted as Section 9 of a British Act of Parliament. Could the British Parliament repeal or amend the Commonwealth Constitution, either with Australia's request or even without it? And could this be used as a way for Australia to avoid having to hold a referendum? The answer is no, because Section 1 of the Australia Acts, in both the British and Australian versions, says that no act of the United Kingdom passed after the 3rd of March 1986 shall extend to the Commonwealth, a state or a territory as part of its law. That means that if the United Kingdom Parliament legislated to change the Commonwealth Constitution, that law would operate as part of British law, but it would make no difference at all to the Constitution as part of Australian law. Now, what about Section 15 of the Australia Acts? It permits the repeal or amendment of the Australia Acts themselves, as well as the Statute of Westminster 1931, by using the same method as is used in Section 5138, and that is the Commonwealth Parliament enacts the law doing the amendment at the request or with the concurrence of the parliaments of all the states. This is relevant to changing the Constitution because it is Section 8 of the Statute of Westminster which preserves the entrenchment of the Constitution and the British Act which it sits within, that is the Commonwealth of Australia Constitution Act 1900. So technically, you could use Section 15 of the Australia Acts to amend Section 8 of the Statute of Westminster to allow the Commonwealth Parliament then to amend or repeal what are known as the covering clauses of the Constitution. So these are the provisions, Section 1 to 8, as well as the preamble, of that British Act, the Commonwealth of Australia Constitution Act, and you could amend them or repeal them to the extent that they apply as part of Australian law. This is relevant, for example, if Australia became a republic and wanted to ensure that its constitution was no longer situated in a British Act of Parliament. It could lawfully be done using this method under Section 15 of the Australia Acts if all the state parliaments passed the relevant request legislation and the Commonwealth Parliament then passed the legislation to get rid of or amend those covering clauses. But does this route allow you to get into the Constitution itself and change it without a referendum? The answer, although it's never been determined by court, but the answer is probably not. The Commonwealth version of the Australia Acts is sourced in Section 5138 of the Constitution. And Section 51 is expressly stated to be, quote, subject to this Constitution. Now, that means that it's subject to the requirement in Section 128 that this Constitution shall not be altered except in the following manner. Okay, so that means that Section 15 of the Commonwealth version of the Australia Acts could not be used by this method to amend the Constitution itself without a referendum. This only leaves the possibility that Section 15 of the British version of the Australia Acts might leave open this back door to constitutional amendment without a referendum. As with its Commonwealth counterpart, it allows its own amendment by the combination of Commonwealth legislation at the request of all the state parliaments. While the British version is not subject to the same restriction as the Commonwealth version, it would seem completely contradictory for a law the purpose of which was to terminate British power in relation to laws applying in Australia to then be able to be used to alter the Commonwealth Constitution. Personally, I cannot see the High Court accepting such an argument, and nor can I see it being politically viable in Australia, as the Australian people would of course be outraged at being disenfranchised in relation to a formal amendment of the Constitution being completed this way. So while people may want to speculate about these rather obscure possibilities, and yes, I've actually written an entire book on the Australia Acts, their history, their constitutional validity, and how they can be used, realistically, the Australia Acts are not going to provide a sneaky way of amending the Constitution without a referendum. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.